For pronouncement of judgment, Timothy Hidaraba versus William Oxman.
We could not accept your submissions. Writ is dismissed.
Apply.
Obliged. Yes.
Yeah, please. With respect to item number 24, Lord, if I may bring to the respondent. I obtain substance from the petitioner. This may be taken up after the beginning. In the meantime, I will file my petition. I have received instruction.
24.
20.
On a request made by Sri S.C. Kyle, Learned Senior Standing Counsel, SCGST. Matter is adjourned by 3 weeks to enable filing of affidavit in opposition.
But it may continue.
Interim order passed earlier to continue till the next date of listing.
May please, Your Lordship. Lord, I beg to mention this item for listing tomorrow, my lord.
Motion.
Motion.
Yes.
May I please, my lord. My lord, with respect to item number 32, my lord.
32, yes.
My lord. Yesterday we have calculated the adjournment with my lord.
Yes. Hearing matters probably will not do today. All hearings.
Due to some personal difficulty, my lord, Mr. B. Chaudhary couldn't prepare this matter, my lord.
We are not take up hearing matters. Okay. Will come
Ma'am,
after the vacation.
Ma'am, please, Lord.
Very interim.
Where? 32.
32.
We are not passing any orders.
Yes,
My listing of repetition, Lord, tomorrow, motion.
Motion, yes, all matters for motion allowed for tomorrow.
Apply.
my lord. My lord, with respect to item number 34 also, my lord. Today we will be filing our affidavit in opposition, my lord.
All the hearing matters will not be touched today.
Predict to mention for listing for motion.
Motion, all motions for tomorrow allowed. No need of mention. Give the mention, ma'am.
Lordship, I beg to mention item number 20.
20.
This yes, sir.
Yes. What is your prayer?
Matter may be adjourned and listed after the vacation.
You are for whom?
Lordship,
You are for whom?
petitioner.
On a prayer made on behalf of the petitioner, matter is adjourned to be listed after the summer vacation. Yes.
Lordship, I beg to mention item number 26. Lordship,
26. On behalf of whom?
take a protest, Lordship.
26.
Yes, Lordship.
I think you're mistaken. AK Purkasta is in 28. Hearing matters no need of mention. Hearing will be after the vacation. We are not taking up hearing matters today.
Wait, if I may mention item number 27, my order matter.
Hmm.
My lord, in this case, what happened, the writ petitioner having died, my lord, he was substituted, order was passed for substitution. Then we were required to file, my lord, amended postage. That somehow been left out, my lord. That we have done today, this morning, man.
Okay.
Kindly, my lord, adjourn it till after vacation.
Okay. Sri B.D. Goswami, Learned Counsel for the petitioner, has submitted that the amended cost title has been filed
This morning.
today.
Yes.
Full stop. List after the summer vacation along with the amended cost title.
Much of me.
Revenue, anybody? Ms. Sri N. Das, Learned State Council, and Ms. G. Hazarika, Learned Standing Council Revenue are present. GMC is also there. Anyone for GMC? Asbora?
As for.
Huh? Asbora, GMC.
Much. Item 27 for withdrawal.
Lordship, I would like to withdraw this matter that actually the matter has become infructuous now.
Why?
And the appellate court has already passed an order. It is actually not communicated. It is passed on 16. So
Sri J. Das, Learned Counsel for the petitioner. No, in this writ petition, notice was issued on 24/6/2025, returnable by 4 weeks, full stop. However, this mention has been listed again today on the strength of a mention On the strength of a mentioned memo, para, Sri J. Das, the learned counsel for the petitioner has submitted that the appellate authority has already passed an order and therefore this writ petition has become infructuous. Para. Also heard Sri
I have a quick question of.
Sri N. Das, learned state counsel, as well as Sri S. Bora, learned standing counsel, GMDA. Para. What do you say? Appeal has been.
The order has been on
Oh.
19th itself, the order has.
The writ petition accordingly is dismissed as infructuous.
Obliged.
Okay, sir.
Lordship, matter may kindly be taken after some time.
What is this matter, madam?
Lordship, here the petitioner and his 6 brothers had a honor of land measuring 48.
Demarcation.
Lord,
I got the
Yes.
instruction, man.
Yes, what is it?
It's second page, para 7.
What is the instructions?
Shall I read? Second page, para 7.
Yes, please read.
The answering respondent number 4, based on the concerned Lot Mandal field inquiry report, we'd like to inform you that the land where the demarcation sought by the application in the writ petition had been eroded up to the radius of 1 kilometer.
Then we'll issue notice, you file affidavit.
Yes, ma'am.
Lord, let the file affidavit.
Let- we issue-
It is on motion stage, it can be.
Motion stays why affidavit should be filed if
Because-
we are not issuing notice. They'll respond only if you issue notice. Heard.
The subject may be given.
We'll give heard Sri J. Ahmed, learned counsel for the petitioner. When this petition was moved earlier, comma, the learned state council was given time to obtain instructions, which has been done. Para. Matter relates to a prayer for demarcation of land. Whereas, however, as per the instructions, comma, the land in question is affected by erosion and certain other aspects have been stated. Full stop, para. Let notice be issued, returnable by 4 weeks. 3. And thus, learned state council accept notice on behalf of respondent 1, 2.
Number 2, 3, 4.
1 is who? Revenue, okay. Ms. J. Hazarika, standing council revenue 1, 2, 3, 4, and thus extra copies by the next date, comma. By the returnable date, the affidavit in opposition may be filed. Yes. Item 2.
May I please your lordship?
Yes.
I beg to mention item number 2. Kindly matter may be passed over for the timely.
If your lordship,
Yes.
is
I have extra copies are my parcel to earlier order.
Hmm.
And this case, my lord,
You have got the instructions.
no instruction is awaited, my lord.
Will issue notice.
Here is an earlier order which they have also annexed, my lord.
Okay. Earlier order by this court.
Some other same matter, my lord.
Okay.
With the same content, with the same,
Okay.
that was my only
it
for
can be
reference.
disposed of with this.
No, my lord, I am seeking my lord relief as per my prayer.
The state council is submitting that
state-
it can be disposed of in terms of the earlier order. Are you?
My lord, there is no, I have the, in this case, my lord, there is no earlier order. Whatever I have annexed is the order of the different case, my lord, for a reference. But I am not seeking relief on that ground.
My lord, lordship come to para 11, page.
My lord, notice may be issued.
What is your grievance?
Grievance, my lord. I have applied for sale permission, which is still pending. On appearance, my lord, before the authorities, They are saying that due to, although my lord, it is not on
Okay,
record.
heard. Sri H.R. Chaudhary, learned counsel for the petitioner, whose grievance is on account of the non-finalization of the sale, of the registration of the sale, which she had applied on the strength of a sale agreement. Full stop. Para, let notice be issued. Returnable by 6 weeks. 3, Miss G. Hazarika, Learned Standing Counsel Revenue, 1,
2 to 5, my.
2, 3, 4, 5,
Five.
and us. Extra copies. Yes.
Extra copies, my lord, I have already served.
No,
Okay,
it's
let's
not.
Madam,
ma'am.
extra copies served upon you?
Served, my lord.
Okay,
I have-
extra copies
I
लिखे
have
होना लगा.
served.
You'll have to serve upon me.
My lord, 5 copies I have served, all 5 copies, all the respondent.
Give one more copy.
How like it? It was in the applicant.
Extra copy लिखी हुई.
No, my government of.
May I please, not very limited prayer, is land acquisition matter and petition case is pending since 2016. And thereafter on 2022, since last 2022, there is no listing of the matter. This is my prayer. Disposal of the matter. Because arbitrator is the lower Assam commissioner is there. But
Is he still the arbitrator? Lower Assam Commissioner?
it is
Yes.
a police.
Why hasn't he proceeded 2016 matter?
I'll have to get it.
Commissioner lower Assam.
Lordship, that
Now, who is the arbitrator now?
packet, that
There is a change in the arbitrator. That is why we are asking.
Yes, my.
was the.
But we have to take steps for transferring to the appropriate authority for a pending matter.
Yeah.
Okay. Heard Sri A. Sharma,
Yes, sir.
learned counsel for the petitioner who is aggrieved by the pendency, by the long pendency of arbitration case number RR 10 of 2016, which was filed before the Lower Assam Commissioner,
Yes.
who was the designated arbitrator. Para? On the other hand, both Sri N. Das, Learned State Council, as well as Miss G. Hazarika, Learned Standing Council Revenue, have submitted that there is a change in the arbitrator and as presently that the post of Lower Assam Commissioner is no longer existing and the responsibility of being an arbitrator has been vested with the Secretary,
Right.
Revenue Department. Para? Be that as it may, let notice be issued, returnable by 4 weeks. GAD, A. Fukan, Standing Council, GAD 1, Revenue, G. Hazarika 2, Bodoland. This is NHAI. Secretary and Competent Authority NHAI. 3 and 6. RK Mushari. And as 5, 6.
4 and 5.
4 and 5.
6 to 7.
4 and 5.
4,
And
5,
7.
6.
6 he says that he'll take. 4 and 5 and us. And Bora? D Bora for 7. Extra copies. Okay.
And your breath.
Human returnable করেছে 6 করেছে 4 weeks.
Hey, please, your lordship.
Yes,
The
Madam
petitioner
Chaudhary.
who has been a victim of the indecent acts of respondent number 5 has seek the direction from your lordship in terms of Rule 3B of the MTP Act. Lordship must be having that. She is now in her 24th week, 15 days gestation on today. She's a 20-year-old lady. If I can take your lordship to the MTP Act, lordship. The statement of objection reason.
Yes, so how do you deal with this kind of matters?
Lordship,
My lord, there is an order already annexed to the restitution, recent order. There, my lord, matter was referred to the medical committee, man, who opined, my lord, what is to be done, or whether it
Yes.
should be possible or
On the part of possibility,
Yes.
what about the legal aspect?
not. That part, this particular order
lordship, in fact, a similar.
was allowed in fact, but lord,
Hmm.
you see page 26, my lord,
Hmm.
two small paras.
No, first there'd be two aspects.
Yes.
First is the legality,
Right.
number one,
Lord,
which is most important. Then next is the feasibility.
Lord,
Now, after 24 weeks, is it feasible
Yes,
without
that-
causing any injury or harm to the
my lord.
petitioner? For that, an opinion would be required. Madam, what do you suggest at this stage?
Lordship, rule 4A of the MTP rules, if you are.
No,
lord-
that is okay. Now, what do you suggest to be done today? Today is for motion.
Yes, lordship.
We issue notice. What kind of interim order do you expect?
Lordship,
Should
in
you
fact,
send the matter to the medical committee to examine the feasibility,
medical board may be constituted.
to examine the feasibility
Yes,
aspect?
lordship.
And what about the legality?
Legality, lordship will see, my lord, under 3P.
Rule 3B covers.
The,
the-
yes, the allegation level, my lord, is, my lord, regarding 3B, A, small
Hmm.
a. Under that part, my lord, can.
Third, Ms. B. Chaudhary, learned counsel for the petitioner. Full stop. The petitioner, by this petition, the petitioner is praying for a relief for termination of her pregnancy. Full stop. The petitioner is a victim of rape, which resulted in the pregnancy, and presently the pregnancy is about 24 weeks, 2 days. Full stop. The learned counsel has referred to the Medical Termination of Pregnancy Act 1971, more particularly Section 3
Yes.
thereof, and has submitted that such termination is permissible in law. Para?
Rule
Uh,
4A, lordship,
Uh,
of the MTP rule, beyond 24 weeks, the opinion of the medical board, which has.
She has also referred to Rule 4A on the aspect of feasibility, which also incorporates the aspect of having a medical board and having an examination done by a medical board. Para, let notice be issued, returnable by 4 weeks. Sri B. Gogoi, learned standing counsel, Health and Family Welfare Department, accepts notice on behalf of respondent 1 and 2.
Yes, one and.
What about 3, 4, 3, 4, 5,
5 is appeal.
3, 4, 5, and us?
Foreigner the police, Moniram Diwan. Subsequent. In 5, foreigner the police, Awang police. Should be district deputy. 5 not.
Yes, you're arraying of parties. What is superintendent of police or what?
3.
How do you describe 3?
lordship,
3 and 5. Superintendent of police or what? What about 5? Superintendent of police of a police station. You should take some care, madam.
lordship.
But nonetheless, you take. I think this is should be Guwahati, and the other one is Dibrugarh. 3, 4, and 5. Let extra copies be served. 6 registered posted AD, huh? Ms. Chaudhary, the learned counsel prays for an interim order. Para, considering the facts and circumstances and the provisions of the Act, A capital, in question, comma, it is directed that a medical board be constituted in terms of section 3 within bracket 2 capital D, right?
Yes.
Of the act, and an examination of the petitioner be done, the report of which may be placed before this court on the returnable date. The petitioner would render full cooperation in this matter. Who should see contact?
My lord, let her appear before the my lord superintendent or the principal, my lord, Guwahati Medical College.
Whomever you say.
Yes.
In
Let
this
it be the
regard,
Principal
the
Guwahati Medical.
the liaison may be done by the liaisoning may be done by the principal, Guwahati Medical College Hospital. We make give a returnable date.
Lord,
Okay.
we will indicate the my lord specialists who are to be there in the committee as per the my lord.
No, as per 2D, we have said. List on. We'll have it on 23rd. Is it okay?
My lord, one thing is, my lord, by that time, another 2-3 weeks will go by. That's the issue.
Then you stay on for on 16th,
Yes, my lord. This is purely
Or-
reopening itself.
or if you want on a vacation,
Yes, it will be more convenient. Otherwise, my lord, the purpose will not be served.
Yes, sir.
More than.
when is the vacation bench? Any idea?
30th.
On this.
Right, Lord, that is-
30th will not be possible.
30 it will be difficult.
When is the second one? 10th.
Let it be on 10th.
10th. Should we give it on 10th, madam? 10th? As considering the urgency involved in this matter. List on 10th. This before the vacation bench scheduled on 10th of July.
By 30th, he will appear before the principal. I will indicate. On
Okay.
that day, I appear.
তার উপর লিখবে the petitioner would appear before the principal, GMCH, on
My lord, the 30th or 20, yes, let it be 30th.
on 30.
30.
But if he is not there on 30th,
Then, my lord, they will make the arrangement.
okay.
But instead of delaying it, only
on
that
30th.
time.
On 30th. 30th of June. June. Etu mutat mari jibe mo potke side. Yes.
I may be allowed to correct the area for this.
How you correct? You file an amended thing, cost title.
I'll do.
File an application will allow it.
Much.
This has gone into the CIS. Now it cannot be changed
Right.
unless there is an application.
Much.
May I please your lordship?
Yes.
My lord, this is the second round that I have approached this honorable court. What happened is that I am the proprietor of Lahorijan Tea State. In that area, in a tea garden, the encroachment was going on. So I approached this honorable court in the year 2021.
Hmm.
The honorable court then directed me to make a representation for the
Hmm.
demarcation of every entire land.
Yes.
Till date, that has not been done. Even after having a repeated representations, even there is on the last occasion, that is your lordship will find, kindly come to annexure P6. P6, page 40.
Yes, what do you say?
My lord, I'll take the instruction, my lord, and before that, my lord, my petitioner may award that the title deed is pending in Kolkata. And the petitioner felt that there is a dispute about the ownership of the land and the execution of the sale deed. Title suit is pending. They have filed an application for mutation that is pending. They have filed several petitions in the High Court. Those are all pending, my lord. There is a dispute between the ownership and my lord regarding the execution of the sale deed.
My lord, at present, your lordship will
And
kindly.
if there is a private dispute between the parties, my lord, what is the action can be taken by the authority, my lord? If there is a dispute between the private parties.
My lord, let me clear one aspect here.
I'll
What
take the
my
instruction,
colleague
my
is saying.
Okay, at this stage we issue notice that. Okay.
My lord,
Pardon.
but at present, my lord, a little bit of protection is required because the question is not about private
Protection
property.
in the sense,
My lord, eviction is continuously going. People are coming into my garden.
eviction or encroachment.
Enforcement is continuously going on. I made representation. Tomorrow
Putting
it may.
instructions on this. No.
I'll take that.
Where is this tea garden?
Karbi Anglong, your lordship.
Lahorijan and Nirmal Kumar Tea Estate.
District Karbi Anglong, Lahorijan.
petitioner claims that he purchased the tea garden, but that is a.
There were earlier
My
litigations.
lord, lordship already, this matter, particularly this matter, my lord, lordship earlier issued this matter regarding he earlier approached for the same issue, my lord, enforcement. That case is also pending. He has filed a second writ petition, my lord.
No, first writ petition which has been filed, you have been asked to comply with the direction. You have not complied till
And
now.
thereafter again, 2023, another writ petition by another advocate, not by you. I think you have not instructed properly on that matter.
Is there another writ
My lord,
petition?
my
Can you give the number?
My lord, at this point, I cannot give the number.
Get the number.
My lord, I can give the
Writ
number.
petition cannot be filed continuous
My lord.
for the same cause of action.
My lord.
We'll have it after the vacation. Get the number.
My lord,
But-
at least at this stage, at
But
least at
only
this
in this
stage,
case, they have issued.
at least at
another
this
order.
stage, kindly protect me. If something is there,
If we are not satisfied with your bona fide, where is the question of protection?
no, your lordship,
Where is it? Where
no,
is the
there-
disclosure?
He
Your
has not
lordship will-
stated
your
any
lordship will-
reason about the
disclosure.
title
no, your
deed
lordship will
pending, my lord.
appreciate
He has not
what my
stated in the
learned
writ
colleague is
petition.
submitting. If he's asserting a fact, if he is saying that there is another lit petition is pending, he should have get the number. But
My
at
lord,
present, I am
Mr.
demonstrating.
Bogha, this is at the motion stage.
My
Is he
lord,
required to have
No,
instructions?
what I'm
before
saying
we
is,
move?
let my land be protected at this stage.
Sorry.
So lordship may record
Heard
by
Sri as
submission that the
Gorgo
petitioner
Learned
has not
Counsel
made a
appearing-
statement about the title suit is
appearing
pending.
online. Full stop. However, Sri J. Chotia, Learned Standing Council KAC, has submitted that full disclosures have not been made in this writ petition. Full stop. He has pointed out that though there is a reference of WPC 3329 of 2021 and the order dated 27/2021 passed therein, there are subsequent writ petition filed by the same party.
Right.
Full stop. Para.
Another point, my lord, title suit, my lord. And then he has
has
not
also-
stated.
He has also submitted that civil litigations are pending on the issue. Para. List, in view of the above, consideration of this matter is adjourned to be adjourned till 16th of July.
Right.
On which date Sri Chutia is to place
My lord.
before this court the details of the earlier litigations. Yes,
My
next.
Item 6.
Lord, in fact, your lordship had passed an order in a similar writ petition.
What is the order?
Lord, they apparently are carrying out with the survey, my lord. That has been permitted, but not to disturb our possession. Yes.
Yes.
My lord, otherwise, my lord, we are periodic patta holders, my lord. And there's an
Please,
attempt.
I have received some telephonic instruction just now. This land is required for upgradation of the power grid of APTCL. Earlier, lordship, some portion of land has already been taken under another LA case where 144 crores have taken from the APTCL.
No, we have said that there will be no restriction to
Sorry.
carry out the survey, but their possession should not be disturbed till the next date.
Lord, as because that order is already there.
Yes, heard. Sri B.D. Deka, Learned Counsel for the petitioner, who is aggrieved, petitioners who are aggrieved by
Right.
the imminent disposition from their Miadipata land in terms of an order dated 28/5/2025, passed in LA case number 9 of 2025. What is this order 28/5?
My lord, that's an order of requisition, my lord. That's our challenge, basically. They issued a requisition notice where they have specifically said that they're going to acquire it.
Yes, Lord, initially the 3-1 notice, thereafter in under 6-1 paper publications will be there. LA case, the award will be fixed.
Let notice be issued, returnable by 6 weeks to the H. Sharma, the learned additional senior advocate.
2
of
and
firm.
3.
One is revenue, one G. Hazarika, one 2 and 3, H. Sharma, huh? Extra copies, para. 3, DECA prays for an interim order, para, considering the facts and circumstances, comma. This court is of the opinion that while no blanket order of stay can be passed, it is provided that while
May I pray, Lordship, tomorrow, Lordship, let me get the instructions as because it's for a greater interest.
no, we are not stopping the survey. While there would be no stay on the aspect of carrying out survey over the plot of land, the possession of the petitioner should not be disturbed till the next date fixed. We give a next date
May-
list on
May-
28 7 4 weeks for the huh? 28
WP, should it come up together?
Yes, sir.
a list along with WPC 3227 of 2025.
DPO.
Give extra copies.
Yes.
Your APD cell is not a party.
No.
If-
That they have not disclosed on affidavit what is the precise public purpose.
Yes, next.
May please, Lord.
Yes,
The
Mr.
matter
Thakur.
pertains to illegal transfer of my entire salary, Lordship, to the loan account, Lordship, and for and for placing a hold on my savings account, Lord. Lordship, the fact is that I took two personal loan, Lordship, in the year 2023. One is amounting to rupees 17 lakh 100 and other is 7 lakh
From State Bank of India.
from the State Bank of India.
Hmm.
And as on Lordship 31st March 2025, balance is Lordship 13 lakhs 21,138 and 6 lakhs 74,562 Lordship.
Yes.
Total Lordship 19 lakhs 96,700 Lordship. And
Yes.
Lordship, the bank authority regularly my lord, crediting the EMI Lordship. Your Lordship, I have annexed the loan accounts Lordship as annexure A and B Lordship,
Yes.
case 12. Regularly. Thereafter, Lordship,
You are a salary holder.
salary, I am teacher, Lordship.
Okay.
I am a teacher. Thereafter, Lordship, from the month of March, April, Lordship, entire salary, entire salary, Lordship, crediting to the loan account, Lordship, annexure D, Lordship, annexure, Lordship E, annexure E, Lordship, statement.
Hmm.
In the month of Lordship May,
Yes.
I received 79,779 Lordship salary, Lordship. Out of them, Lordship, 10,000 and Lordship 68,755. Total Lordship 78,755. Credited to the loan account, Lordship. Page 24.
Yes.
Then Lordship, page 25. Statement for the month of May, Lordship, June, Lordship. In this month, Lordship, two amounts were credited to the loan account. One is Lordship 34,270 on 5/6/2025, and again Lordship 46,600 Lordship, total 80,870 Lordship.
Okay.
Then Lordship may
Now, I have to
kindly,
issue notice at this stage.
Lordship,
State Bank of India. Is there a standing council?
there is no standing Lordship, but penny advocate Lordship, PK Sen. On-
No, Mr. Nandi is also there. Yesterday, Mr. Nandi had appeared, KK Nandi. Can you serve upon him? We can have this tomorrow.
Lordship, then one more problem is that Lordship, page 26 Lordship.
No, you
No.
serve upon him. We'll
Lord-
have it tomorrow.
PK
Okay?
Sen.
BKSN or KK Nandi. Yesterday, one case, KK Nandi. Okay. Heard Sri H. Talukdar Learned Council for the. Otherwise, we can issue notice
Lordship, but
or
one-
returnable on the reopening.
Lordship,
Because interim, it will not be possible
Lordship,
without hearing the other side.
Lordship,
Let us issue notice. then.
Lordship.
Heard Sri H. Talukdar Learned Counsel for the petitioner, who is aggrieved by the action of the respondent bank in crediting his entire monthly salary against two loan accounts. Full stop. It is the case of the petitioner that as per agreement with the bank, an EMI was fixed, which was being deducted from the personal account of the petitioner. Full stop. However, from the period March that's April 2025, the entire salary has been adjusted against the aforesaid loan account. Para? Let notice be issued, returnable on, we give a date, returnable on 23rd. Is it okay? 23rd or 21st? 21st of July. Let steps be taken for service of notice upon the respondents by registered post with AD, steps by tomorrow. Informally, you can inform Mr. Ganondi. It will be easier for you. Okay. Yes, what is this?
The petitioner has approached this honorable court for the second time, Lordship. So here in this case, Lordship, the petitioner has challenged the election of the private respondent number 7, Lordship. He was
Election?
elected of a panchayat member, Lordship.
Okay.
And earlier, Lordship, what happens, Lordship, the government of Assam have issued a notification, prescribed the eligibility criteria of a panchayat member, Lordship. And in the state notification, there is a clause, Lordship, which says that, Lordship, the candidate could not hold any.
But who are you?
Lordship, I am a ex-president of that panchayat and a registered voter, Lordship.
Were you a candidate
Lordship,
in this
not a
election?
candidate. Lordship,
No
because,
locus. No locus.
earlier, Lordship, in earlier litigation also, there is a observation of this honorable court, Lordship, that in the earlier litigation, Lordship, a question was raised regarding maintainability of the petition by a voter, Lordship, and the candidate, Lordship, where this honorable court, after extensively hearing the petitioner and the government side, Lordship, has observed that in pursuance to the judgment passed by the honorable court, Lordship, that petitioner as a registered voter cannot go remediless, and he can explore the possibility of filing writ petition challenging the election of a candidate being a voter. But we state observation kindly come to the
Page.
Lordship, 89, Lordship. Para 54, Lordship.
Judgment starts at which? Judgment starts at which page?
Judgment started, Lordship. Lordship, 50 to 92.
Okay.
Annexure 10.
Okay. Which is that?
Petitioner, petition number was
No. Which paragraph are you referring to?
54, Lordship.
54.
54.
Yes, what is it? Please read.
Non-entertainment of the writ petition shall not, however, preclude the petitioner. The case was heard with other cases, Lordship, and
Where is the observation so far as this question is concerned?
Page 50, para 54, entertainment of the writ petition shall not, however, preclude the petitioners who were contesting candidate or had submitted nomination papers to contest the panchayat election to avail their remedy under section 243 OB of the Constitution and section 129B of the Assam Panchayat Act, other than the petitioner number 1 in WBC number 2178 of 2025, Lordship. The petitioner number 1 is the present petitioner, Lordship. The other petitioner would not therefore be precluded from filing election petitioner before the jurisdictional panchayat tribunal within stipulated period of limitation after declaration of the result. Insofar as the petitioner number 1 in WBC number 2178 2025 is concerned, he can explore the possibility of filing a writ petition only after declaration of the result with regard to party respondent number 6. If after declaration of the result of the panchayat election, the party respondent number 6 gets elected.
This observation is in the context of the bar. This observation is not in the context of the locus.
This observation was made in pursuant to the Bharati Reddy case, Lordship.
No, this is in context of there is a bar that once the election process starts, you cannot challenge unless the results are declared and only by an EP. So what about a candidate who is not, what about a person who was not a candidate? You cannot file an election petition.
Yep.
For him, the bar will not be applicable. We are on the aspect of your locus.
Locus Lordship, in Bharati Reddy's case also, a general voter has challenged the election of a Adhyakshya Lordship. And
Let us
on the
see.
basis of the said writ petition, the post of the
Yes, what
Adhyakshya.
do you say?
That-
Now the representation has been rejected.
Lordship, the petitioner has filed the representation before the authorities, Lordship, when election result was not declared, and he was going to be contested in the case. That representation was not considered. Thereafter, he approached this honorable court, Lordship, and this honorable court, Lordship, has observed
Now what has happened? What is the fresh cause of action?
he has already been elected, private respondent number 6. And I have a document with me to show that he is not he's a eligible candidate. to
What is
contest.
your grievance now?
Grievance, Lordship, as a voter, Lordship, he as an ineligible candidate
No.
is
That we have understood. Eligibility, ineligibility. You had come to this court earlier.
Yes.
Then thereafter, what had happened? What is in the intervening period, what is the development?
the development, Lordship, private respondent has already been on the elected, Lordship. And today, Lordship, at 2 p.m., Lordship, court taking ceremony will be held, Lordship. And
You should participate in the door tapping ceremony. You should be happy with something. Somebody has won at least.
He is totally ineligible, Lordship. Some eligible candidates were there because of him, someone not.
Yes, we issue notice at this stage then. For that part, we still have some doubt. That observation is not with regard to the locus part. It is on the legal bar.
So far as the repeat judgment was relied upon, but there was one more issue. The writ of certiorari would be applicable also. So far as petitioner is concerned, maybe Lord, he may have a case for writ of quo warranto,
Quo warranto.
because he is challenging the eligibility of that kind.
He is
on
not
that-
praying quo warranto. It is not a writ of quo warranto.
If he comes within, because there the locus is diluted, my lord. And what the apex court said in the earlier round, my lord, your lordship has held.
Bharati Devi, which writ was involved? Quo warranto?
Yes, Lordship.
In Bharati Devi?
Yes.
Have you played for quo warranto?
Yes, Lordship.
You have played for quo
Yes,
warranto?
yes.
Where? Let us see. He has mentioned quo warranto. Certiorari, quo warranto, everything. He has not taken any chance.
In the paragraph.
Mention everything, something may strike.
Page 74 of the judgment, Lord.
Okay,
para 32.
third. Your beholder,
Yes, Lordship.
learned counsel for the petitioner who is aggrieved by the action of the respondent authorities in holding the respondent number
7 here.
7
6 there.
to be eligible. 7.
7, Lordship.
7 to be eligible to contest the elections under the Assam Panchayat Act 1994. Full stop. He has submitted that the said respondent number 7 is disqualified under section 1112,
111.
1112,
Still what one?
1 or 2.
People want one email.
1111E of the amended provision. Full stop. The learned counsel has submitted that earlier. Also, he had filed writ petition 2178 of 2025, wherein it was provided that after declaration of the results, the petitioner may approach the court. Para. Let notice be issued, returnable by 6 weeks. Panchayat Rural Development is K. Kaur. You have appeared as what? Learned Edition AG accepts notice on behalf of respondent number 1. 1456. R. Dubey for 2,
2 and 3 months.
2 and 3. Extra copies. Let steps be taken for service of notice upon the respondent number 7 be taken, by registered within 2 days, 2 working days. Sri Haldar prays for an interim order, para. After consideration, this court is of the opinion that no interim order is called for at this stage, full stop. However, all actions taken pursuant to the
Election result.
pursuant to the results of the election would be subject to the outcome of this writ petition. Yes, next.
Election result dated 12/5. Value of
Item 9.
Mr. Gaur,
My lord. My lord, in this case, my lord, petitioners and respondent 528, my lord, they are co-owners of a plot of land, my lord. My lord, their predecessor in interest, my lord, in the 1991, my lord, constructed the building, my lord, ground floor 2. Now, my lord, the private respondents are constructing, my lord, in spite of written complaint by the petitioner, my lord. When my first complaint was made in May 24, my lord, they stopped the work. Thereafter, my lord, they again started the work and the complaint petition made.
5 to 8 are having constructions on the 3rd floor.
My lord.
They had purchased the 3rd floor or what?
No, my lord, my lord, earlier, my lord, ground floor 2 was there, my lord. In the year May 24, they started 3rd floor, my lord. When I made the complaint, my lord, they stopped the work. GMC stopped the work, my lord. Again, my lord, in May 25, my lord, they started the work.
Heard Sri J.C. Gaur, learned counsel for the petitioners who are aggrieved by the inaction of the respondent Guwahati Municipal Corporation to take action against the illegal construction of the 3rd floor by the respondent numbers 5 to 8. Full stop. It is the case of the petitioners that on an earlier occasion, such an attempt was made, which was however stopped after a complaint. Para, let notice be issued, returnable by 6/6. Ms. H. Barua, learned counsel accepts notice on behalf of respondent number 1, 1, 2, 3, 4. Extra copies 5, 6, 7, 8 registered posthuity steps by tomorrow.
My lord, there are.
Para pendency shall not be a bar to consider the complaint of the petitioners.
My lord, they are 4th floor, they are also 3rd almost completed, my lord. For now, they are constructing 4th floor. My lord, at least.
You might get 2 floors for free. On their cost, you might get 2 floors, 3rd and 4th.
No, my lord.
Okay, next.
Ulaz.
Give her extra copies.
Item 10.
Here, my lord, the petitioner, my lord, they have, my lord, applied for a sale permission before the circular officer. But the sale permission the sale permission was not entertained only because of the land was sold to, my lord, a person who belongs to other community, Muslim community. That is the case here, my lord. Your lordship will find annexure 4, my lord, page 15. This is the sale agreement, my lord. The petitioner.
Yes. We should notice at this stage. Your MA Islam.
My lord.
Heard Sri MA Islam, learned counsel for the petitioners who were aggrieved by, has it been rejected?
Even no, my lord.
By non-consideration of the sale permission in terms of an application made on 2/6/2025. It is the case of the petitioners.
My
that
application has been returned to me, my lord. Not even processed, my lord. Initially accepted, but later on.
It is the case of the petitioners that the application was filed after an agreement, which however was returned without even consideration. Let notice be issued, returnable by 6/6.
For date.
Vacations are there.
Otherwise, the petitioner.
4 weeks. 4 weeks.
75-year-old lady, my lord. Only because of the problem is here, my lord. The petitioner number 2 is the son, my lord. He is settled at Bongaigaon. And the lady.
Okay, 4 weeks we have said.
My lord.
Revenue. Yes, PR Mohanto, 1.
2 and 3.
No, only 1. You are for 2 and 3. Okay. H. Sharma. Additional senior government 2 and 3. Extra copies.
11.
May I please, Lordship?
Yes, Mr. Fukan.
Yes, Lordship. During the investigation process, the account of the petitioner was seized by the investigating.
Bank account.
Bank account.
Hmm.
Under section 94 PNSS, the section itself not providing any fees or seizure, etc. It is totally illegal and arbitrary in nature. So, and the
Heard Sri B. Fukan, learned counsel for the petitioner, who is aggrieved by the action of the respondent authorities in freezing his
Freezing
bank account.
bank.
Full stop. He has submitted that the said action is wholly violative of section
94 of
94 of the BNSS. Para. Let notice be issued, returnable by 4 weeks. Sri H. Sharma, learned additional senior advocate, accepts notice on behalf of respondents 1, 2, and 3.
Lordship.
Extra copies. Who is 4? By name?
Or by name, he sub-inspector.
Let's steps be
is the
taken
director
for
of the
service of
freezing
notice
director.
upon respondent 4 and 5 by registered post to TD. Steps by 2 days. 4 and 5 registered post.
Or apply.
Yes.
Item 38 of this.
Yes. Miss-
Under the spot fact of the case is there, the predecessor of the petitioner lordship, father of the husband of the petitioner number 1 and the father of the other petitioner, purchased a plot of land lordship in the year 1995. After the death of the lordship, the predecessor, when
Hmm.
this petitioner lordship approached the authorities, they have found that name of the private respondent number 6 has been recorded in the land record. And thereafter lordship, a petition was filed before the settlement officer. And settlement officer has passed an order cancelling their mutation and directing the authority to incorporate the name of the present petitioner. Challenging that order, lordship, the respondent.
What is the order of the Board of Revenue?
Yes, lordship, page 85.
7325.
Lordship,
7325.
7325, lordship.
Acha.
But although this judgment was lordship, in fact, was kept reserved. I have annexed that order, page 19.
Okay, heard Sri M. Khan, learned counsel for the petitioners who are aggrieved by the judgment dated 7/3/2025 passed by the learned Assam Board of Revenue in case number 17 RA Sailab.
17 RA DBR.
Oh, Sailab. By the impugned judgment, the order dated 30/12/2017 passed by the settlement officer has been set aside with a further direction to restore the name of the private respondent number 6 in the land record.
And
The
there are,
petitioners have also been directed
yes,
to vacate the disputed land. Full stop. The learned counsel submits that the subject matter was raised by the respondent number 6 earlier
Yes.
by title suit 65 of 2023. And it is the competent civil court which would be the jurisdictional court to issue such direction.
Yes.
Para. Let notice be issued, returnable by 4 weeks. Revenue, Miss P.R. Mohanta 1,
225.
H. Sharma additional Senegal 225. Extra copies 6 registered post with AD. Steps within 2 days. Extra copies steps within 2 days. Heard the learned counsel on the interim prayer. Let notice be issued on the interim prayer also. Till the next date fixed. It is however directed that till the next date fixed, the petitioner are not to be dispossessed from the land in question.
Yes.
Since this interim order has been passed ex parte qua the private respondent, they shall have the liberty to apply for modification, alteration of the same.
Item 39.
May I please your lordship, my lord, the petitioner before lordship approached this whole court on apprehension of eviction. My lord, they are residing in the village Bolatmari, Muriamnagar district, Gwalpara. And the father of the petition number 1, 2 and 3 earlier filed a title suit claiming right title and possession about the land. And in appeal, in title appeal.
Is it
to-
forest land? Yes, Mr. Botakur?
Here, there is no notice in this petition. My lord, my lord.
My lord, the apprehension.
Kindly have a look at, my lord, the annexure 16, the proclamation of notice. Proclamation of notice.
No,
My lord,
proclamation is not eviction.
This notice does not include our area, my lord. But
So why are you apprehending?
forest officer has visited our house, our residential area, and they have perused our documents and saying that the orders are old, so you take a face order, because the earlier, my lord, we have approached this honorable court by filing a writ petition, and that order, lord, you will find in annexure 5, page 64. This honorable court has passed order, the operative portion at page 66, that without due process, nothing to happen. And these order also produced, this civil court orders also produced. They are saying that these are old order, now with fresh order. Therefore, we have,
Where is the cause of action?
my lord, I have stated in paragraph 7 and 8.
Old orders or new orders? Orders or
My
orders?
lord, they have visited our house and they have, my lord, they are saying that
You take instructions, we'll have this for motion.
I'll take it.
Hearts. Restrict
My
the
lord, till then some interim protection, my lord.
learned counsel for the petitioners who have approached this court with an apprehension of eviction from the plot of land under their possession. 3. I, Botakur, learned counsel appearing for the forest department, has however submitted that no notice of any such eviction has been enclosed to the writ petition, and it appears that it is merely on the and it appears that the writ petition has been filed merely on speculation. Para. Sri Sigda de Learned Counsel has however clarified that though the petitioners had earlier approached this court and there were orders passed protecting their rights, they have been informed that the said orders are old orders. Full stop. Para. Be that as it may, let instructions be obtained by Sri Botakur. List this case on 16th of July. To facilitate obtaining of instructions, let an extra copy of the writ petition be served upon him during the course of the day.
My lord, till then no coercive measure. Authorities will follow the law. That
Sri Sigdar prays for an interim order. Para. Though passing of interim order even before issuance of notice may not be proper, it is provided that no actions be taken without following the due process of law.
deep law, please.
Maybe, in this case, I filed caveat, my lord. Caveat was not taken also, and my copy also not served earlier. Just half an hour ago.
What is the matter?
The matter-
Election, no
Yes, my lord.
confidence.
Yes, my lord.
Yeah,
No confidence.
No, my lord. Actually, the date of birth of the respondent number 7, my lord, 10/6/2004. And the last date of submission of nomination on 11/4/2025. On the date of nomination, my lord, the respondent number 7 was 20 years, 10 months, 1 day. But as per section 111J, 1J, and the Adam.
You say that he is disqualified.
Yes, my lord.
Yes, what do you
Disqualified.
say?
I have clarified the position by filing affidavit before the deputy commissioner at the time of filing my nomination paper. All the documents that.
Now you have been elected.
Yes, my lord, I
Yes.
am elected, my lord.
Okay, we'll issue notice at this stage.
Only notice, my lord.
But my lord, one thing, my lord, after submission of our complaint, my lord, hearing already conducted by the office of the deputy commissioner 126, but order not yet passed.
We'll say that let the pendency shall not be a bar for passing orders.
Yes,
My
my
lord.
Okay. This is
But-
item number,
But,
bring your caveat, okay?
Right.
but one thing, my lord, the
Heard,
swearing
you
ceremony,
are MR Chaudhary,
K.S.R. Ahmed.
HR Ahmed.
swearing,
Heard Sri HR Ahmed, learned counsel for the caveat, who has lost this caveat in respect of his election.
Yes.
Full stop. The caveat would be heard in the event this court considers passing of an interim order. Para, caveat stands discharged. With law and, you bring it, give a equation.
Right.
Heard Sri M. Hussain, learned counsel for the petitioner, who has put to challenge the aspect of the eligibility of the respondent number 7 to contest the panchayat elections
panchayat election,
As a member.
as a member.
as a member. It is the case of the petitioner that the petitioner is disqualified on the age ground. On this respect, the petitioner has already filed a representation before the deputy district commissioner,
My lord, before the election officer,
before the
District
election
elec-
officer, which has not been considered. Para,
Well-
let notice be issued, returnable by 4 weeks. Panchayat Rural Development, Sri K. Kumar, Lieutenant AAG, accepts notice on behalf of respondent one. One, not four also, district commissioner will take.
Yes, I am.
Okay, 1, 4, and 6. R Dubey, 2, 2 and 3. 2 and 3 and 5. 2, 3, 5. Election officer. Extra copies. 7 registered postal ID, huh?
I have got something.
Sri Ahmed, the learned counsel. Oh, you are appearing for 7, no?
7.
Ahmed for 7, no? Sri Ahmed, the learned counsel, has submitted that there is no merit in this petition, as the issue regarding age has already been clarified by filing of affidavit. Full stop. Yes,
But kindly, para 6,
yes.
contesting it. He is allowed to repetition, but the
Elections are already held.
but he can challenge by way of election. He is a contesting candidate.
Oh.
Allowed, not allowed,
Okay. Oh,
not a voter as such, but
but petitioner number 1 is the voter. my lord.
no, Mr. Dubey, all said and done. The restriction is only, embargo is only on the aspect of the ongoing elections.
Yes,
The aspect where you challenge is not, the objective is not 329B, if you read of the Constitution of India.
Yes.
That is only not to stall an election. Whether you raise in an election petition or 8%, that's a
but
different.
his locus is to file a election petition.
Understood, but there may not be, there may not be absolute bar. The bar was only not to stall the elections, the objective.
The other part is also there.
Sri Dubey has also, has however raised the objection of maintainability of this petition, the petition number 2, as he was a contesting party in the said elections, wherein a remedy of filing an election petition is available. Yes.
Obliged, my lord.
my lord, one thing, my lord, maybe consider, my lord, swearing ceremony is going to be
Outside ballot
on 30, my lord.
You participate there,
My lord, how I,
and you can have some new grounds on the next date.
my lord. Date may be given, my lord.
Come on, it's 4 weeks, again. 4 weeks, we have said.
My lord, one thing, my lord, subject to outcome of the request, my lord.
That is always there.
My lord,
Okay,
that-
all actions taken pursuant to the election of the private respondent
Okay.
shall be subject to the outcome of the writ petition.
Obliged.
Obliged. Item 12 and 41.
Lord, the IA we have filed for modification of the interim order, Lord, order dated 4/3/2024 at page
First day,
16. Lord.
first day,
It has come for the first day.
first day, yes.
Lord, the
And
aspect,
the
aspect
You,
of the
you don't like to file
We
objection.
have objection file, my lord, it is not on record, my lord, yes,
Yeah.
that we have filed.
You have filed already.
Yes, my.
Before issuance of notice.
In fact, the honorable court has directed that in the interim, it is directed that the petitioner shall not be evicted from their land, which is located at Peltoli Daily Bazaar under Thagorijan Antolik Panchayat till the next returnable date. Well, there is a work for construction of a bridge, and their shop is on the way. Just towards the bridge, and in the writ petition, they have come up with a representation that that particular road is not required, that bridge is not required at that particular place. I have the photographs, that
Who is the applicant?
applicant is the chief engineer.
Why is he by name?
It's a mistake.
Why is he by name?
In
He
fact,
comes as the chief engineer, the department comes, the chief engineer comes, not the person.
that
This matter will be adjourned for the time being, my lord. My senior is come.
Your objection is on record.
My lord,
Your objection is on record.
is not on record.
We have it tomorrow.
or let me hear the matter.
No, without the objection on record,
That-
not be possible.
Then on 15th of July.
On 15th?
Yes.
On 15th.
Okay. Heard Sri D. Nath Learned Council for the applicant who by means of this application has sought for modification, cancellation, alteration of the interim order passed in the connected WPC 1129 of 2024. Para? 3. This is item number what?
Item number 12. Our I is item number.
Okay. Sri S.R. Borbuya, Learned Counsel for the opposite party writ petitioner has however submitted that objection has already been filed, which
I have-
however is not on record.
I have not received a copy. I'll take a copy.
Have you served copies upon them?
No, I have not. I'll take a copy.
When did you
Yeah,
file?
Otherwise, would not,
When did you file?
would not,
There are-
yesterday, my.
There are other responses
Yesterday.
they may have given to that. I'll give me a-
Which is not on record, Para? In the interest of justice, consideration of this matter is deferred to 15th of July,
15th July. Lot.
by which time the objection may be tagged with the records.
Lot.
The Para interim order passed earlier to continue till the next date of listening.
Lordship, I am appearing for item 41, Lordship, connected matter, Lordship.
41 is connected.
Yes, Lordship. I
What
am,
is 41?
I am for respondent number 10 in the writ petition, Lordship. I am the contractor, Lordship.
You have also filed IA for
Yes,
vacating.
Yes, Lord.
They have filed objection.
No, yesterday I have filed, Lordship.
Okay.
Copies have been served. really.
Okay. IS Civil 2099 of 2025, which has been listed today as item number 41, may be tagged along with this case.
Lovely.
You file objection in this case also.
Oh.
Okay. Item 13. Yes, what is this?
That is the Lordship. In this petition, Lordship, we have challenged the assessment order on 3 points on the jurisdiction of the assessing authority, where one of the point has been settled by this honorable court in the case of Lakshmi Narayan Sahu, that's 2018 4 DLT, which has been submitted by my learned friend. That was in respect of after the Goods and Service Tax Act was brought into force and by the constitutional amendment, The power
That
to-
was the submission of Mr. Kyle that it is covered by Lakshmi Narayan.
Yes, Lordship. That
Yeah.
covers one part of my point of contention in this petition, Lord. So far, the jurisdiction is concerned. That was in respect of, Lordship, when the new GST Act, by the way of repeal and saving section, had saved the exercise and continuity of the powers of the authority under the Service Tax Act, which was under Chapter 5 of the Finance Act 1994. Whether that will continue. So that part has been set at rest. Now, another point of contention before Lordship is when from the Constitution, the entire power to levy service tax has been totally deleted. Whether they still have power to continue when the constitutional power itself is deleted.
No, this section was taken prior to the deletion. When is the action?
It is subsequent to the deletion. My impugned estimate
Mr.
of the-
Kyle, what do you say?
Lordship, this is
These
the-
are, I think these are issues are covered.
Yes, this is covered issue, Lord. And every time, Lordship, the case is listed, my management is taking time.
No, he's not taking time today.
No, no,
No,
Lordship, Lordship, please proceed.
No, today he is not taking time. Today we are disposing
There
of
is
this
submission,
matter.
Lordship, many occasions he is also not available.
Lordship, please to check up the records. If I am wrong, Lordship, then I'll withdraw from the.
Need not be so serious.
No,
At,
Lordship,
at times,
since 2018.
yes, he has
the-
taken adjournment, but today he is not taking adjournment. Today he is ready for a final
And
disposal.
Lordship, this issue was decided by this.
Mr. Todi, we have seen cursory had a cursory glance. Issue appears to have been covered. All the points.
But constitutional point was not considered in that judgment, Lordship. The Lordship have the copy of the judgment.
Yes,
Lakshmi
we
Narayan.
have, we have seen the
Yes,
judgment.
Lordship. If I may,
But Justice Buzar Burwa.
Yes,
Lordship, if I may just bring two paragraphs from the judgment, Lordship, and how my contention which still remains is differs from the judgment.
Yes,
Lordship may first come to paragraph 2. Lordship is having the judgment.
yes, yes.
In all the writ petitions, the demand cum so-called notices of various days issued by the Assistant Commissioners, Central Goods and Service Tax Act of the District of Dibrugarh and Guwahati respectively are assailed. The state demand cum so-called notices are purportedly issued under Section 75, 26, and 78 in respect of proceedings initiated under Section 73(1) of the Finance Act 1994 for failure on the part of the petitioner for paying service tax that are leviable upon them. In all the writ petition, demand cum notices are assailed on the ground that in view of the provisions of Section 173 of the Central Goods and Services Act, further proceeding.
Okay, we'll do one thing. We'll have this after finishing of the other admission.
But-
This will take up for the disposal, other admission perhaps,
Sure.
because hearing we are not taking today. Okay, after a while. This might take some time.
Sure.
Please don't go away.
Yes,
Yes, next.
Lordship, my senior counsel is in another court. Kindly this matter be taken up after some time.
What is the matter about?
Lordship, I don't have file with me.
This is regarding eviction, roadside eviction lot. Eviction has already been carried out.
What is there to be adjudicated? 18 matter eviction already carried out.
Got-
At best, you may have some case for compensation if you
Okay,
can prove that you are a bona fide holder of the land. You are an encroacher.
Lordship, there is an order passed by the Honorable Court on 11/4/2018, wherein interim order was granted pursuant to their.
We'll close this. We'll close this. Ask him to come. We'll close this today. After a while. 18 matter.
My Lordship,
Yes.
Lordship, I have to file the counter affidavit.
Counter.
For that, Lordship, I
Not
need-
counter. Rejoinder.
I
affidavit.
apologize. There was a misunderstanding with my clerk. I had believed that affidavit was actually served on the petitioner. It was served on a different counsel of the same name. I need some further time to serve it properly, man. I'll take steps personally.
But has it been filed?
Well, it has been filed. It was served on a different counsel with the same name. Well, that
No.
confusion came.
Let him serve a copy.
Yes, Lord, because I need that copy only to file the counter.
Now have you been served now?
During the course of the day, I will, after taking a copy from the.
Okay, you are for whom?
Like,
LIC, and you are for?
I have put the correspondence 4 and 5, hospital and doctor.
Your affidavit will be required.
1, 2, 3. I have done it with my. Yes, yes. I have
Okay.
received the
Okay.
copy
Okay,
from the other
ma'am.
hospital.
Though affidavits have been exchanged, comma, Sri N. Barua, learned counsel for respondent numbers 4 and 5, has submitted that due to some confusion, the copy of the affidavit in opposition by his client was served upon another counsel. So he, however, undertakes to serve a copy of the affidavit in opposition to Sri Kolita during the course of the day. Learned counsel, Kolita, learned counsel of the petitioner. Para? Let this matter be listed after 4 weeks to enable filing of rejoinder affidavit, if so advised.
Apply.
Matter
Three-
pertains to Panchayat delimitation.
Panchayat delimitation.
Yes, ma'am.
Case similar matters are disposed of in the covered judgment.
Covered.
Covered with, otherwise, my cause of action is little different. Covered means, although it is related to Panchayat delimitation. All the Panchayat-
Delimitation, detailed judgment has been passed. Why should we again explore? Give a copy of the judgment.
We are not holding the copy of the judgment here.
Give the number, at least we can take
Yes,
out a copy.
Yes, elected WPC number 5346/2024.
Okay, our court master will help you take out the copy. How big is the judgment?
195.
Only? No need, please don't.
But basically, yesterday I had carrying.
Now
So
we'll
that some other cases have also been.
now we'll check in the net. No need of wasting pages. Okay, give the number. We say what is the outcome. Otherwise,
Has been
yes, miss. Heard. This is item number HR. Heard Sri HR Chaudhary, learned counsel for the petitioners. Also heard Sri K. Kwon, the learned AAG Assam, as well as Sri R. Dubey, learned counsel, standing counsel for the State Election Commission. Full stop. The challenge in this writ petition was in respect of the action taken by the District Delimitation Commission. Full stop. The petitioners are aggrieved by change of their words. Full stop. The learned counsel for the respondents have, however, informed that this issue, along with connected issues, have already been decided by this court in a series of writ petitions. The lead case being
5346/2024,
5346 of 2024, judgment dated
24/4/2025.
24, full stop. Whereby the challenge has been rejected. Para. On perusal of the copy of the said judgment, it appears that the issue raised in the present petition is squarely covered by the said judgment. Full stop. Accordingly, the writ petition stands dismissed. Number 2 falke likhise. Judgment dated. Judgment by which court?
9.
Justice?
Justice Mr. Sood.
Oh. M. Chaudhary. Fairly.
Item 17.
May I please?
Yes.
Kindly see page number 22, my lords.
Page number?
Page number 22, my lord. Respondent authorities, my lord, illegally excavating the river bank, my lord. Due to
Illegally?
excavating the river bank, my lord.
River bank.
Yes, my lord. Due to that, my lord, I am subjected to irreparable loss and diminishment.
Who are you?
I am the landowner. I am the owner of the riparian land.
Yes, instructions.
Lordship, I have received one inspection, but this is regarding the forest department, Lord. The instruction that matter has already been settled I have received instructions from the superintendent of police.
Mr. Laskar, the matter has been settled.
I have no any instruction. my lord.
Parvez Alam Chaudhary, you are Parvez Alam Chaudhary.
Yes, my lord.
That paragraph
Why?
I put to put.
Who?
I would.
regarding.
Forest Department. This has been settled. We'll close this. We'll close this in view of this. Clear that without affecting his
Chair,
rights.
Another date may be given. I have the instruction from my client.
This is of the March 2025. Your client has not informed you. We are in the end of June.
I will take instruction, my lord, another case.
You take telephonic instructions. We're having this tomorrow.
Lord,
The challenge in this matter was the lack of action in protecting the land of the petitioner. Full stop. The projected case of the petitioner was that the bank of the river was being excavated, which had the propensity to affect the land of the petitioner. Para. Sri H. Sharma, the learned additional senior court advocate Assam, has however placed on record written instructions dated 28/3/2025, as per which the matter has been settled between the parties, with a further note that the petitioner's bona fide land would not be damaged. Full stop. As the learned counsel for the petitioner, the learned counsel for the petitioner has however sought some time to obtain instructions. Para. List again tomorrow for admission. একটু হুনকারে মারি দিও।
Made the purpose. So 9 board of directors of Badgaon Noyapara Samavai Samiti Milot filed
for the private phone number 9 and 10.
Okay.
We want some time to file affidavit.
Who is for 6? 6, who is for 6? 6 has filed affidavit in opposition.
yes, 6 is filed by the previous Milot, which may kindly see.
Deputy
Deputy Registrar Cooperative Society. But
Who will file affidavit?
9 and 10 for a private respondent, president and secretary of that.
And Mr. Sharma? You're for Cooperation Department.
This one fishery department. Not
Fishery. Okay, you will file for whom?
is for register. Yes, right.
Taruda is for Cooperation Department.
Yes.
Now, would you like to file? Who would like to file affidavit? You would like to file affidavit? Okay. Okay. Out 3 and Bora, learned counsel for the petitioner, who submits that notice was issued on
Pankita Gogoi.
12/2/2025. Full stop. By R6.
Okay.
R6, it's been filed already.
And para 9 Milot. On record, Milot says that they sent to the hearing and reschedule. Para 12 Milot, para 12 Milot. On record, they say, but no copy was sent. Para 12 Milot.
Though R6, respondent number 6 has filed affidavit, comma, a prayer for grant of time has been made by 3 N Hawk learned counsel for the respondent numbers 9 and 10. Para list after 4 weeks to enable filing of affidavit in opposition. By the same time, the other respondents may also file their affidavits.
Until 90.
But here, my prayer is very simple, but I'm taking a direction to the concerned revenue officer to dispose of my application that is pending before them for the last 6 months.
Application for?
For settlement of a plot of land which is under their possession for more than 70 years, during the since the lifetime of the office of the petitioner's forefathers, the land is under his possession. It is a Sarkari land, and there is a residential house also. But my application is pending for the last almost 6 months.
Yes, madam. Instructions?
But application is only 6 months on lordship. 300 days take for the settlement.
No, you take instructions. What is the bona fide of the petitioner, his strength of making the application? Mr. Sharma, you have also any role to play?
We are facing a difficulty, Lordship, no copy is served upon us. So, very often, so we are facing.
Though notice was issued on 24/2/2025, it appears that extra copies of the writ petition have not been furnished to the learned counsel for the respondents. Para, Sri M.A. Islam, learned counsel for the petitioner undertakes to serve extra copies to both Sri H. Sharma, learned additional senior government Assam, as well as Miss G. Hazarika, learned standing counsel revenue by tomorrow.
Okay.
List after 4 weeks to enable the learned counsel for the respondents to obtain instructions.
Item 21, 22.
Yes, Mr. Das.
This case has been filed against the next another BPC authority matter. Notice was already issued. And then
What is the cause of action? BTC, Mr. Mushtari?
cause of
What is the cause of action?
My lord, the petitioner's husband was killed by the extremist and he applied for the job, my lord, under the scheme, my lord.
Okay,
And-
get the instructions, okay. Heard Sri UK Das, learned counsel for the petitioners. Para. Also heard Sri N. Das, learned state counsel, as well as Sri R.K. Mushari, learned standing counsel BTC. Full stop. On the prayer made on behalf of the respondents, matter is adjourned by 4 weeks to enable obtaining of instructions / filing of affidavit in opposition.
Only a date may be fixed.
4 weeks we have said. File it. Yes, next. Twenty-three. Yes, madam, 23.
Your lordship, the respondent has to file reply.
Yes, notice was issued on 5/3. What is the matter about, madam?
Your lordship, the petitioner, he was convicted to undergo rigorous life imprisonment for life. And he has completed, including the under trial, he has completed already 25 years in jail.
You have applied for remission?
Yes, your lordship, and he was.
Yes, please take this matter in the right earnest.
Lordship.
Why is the application not considered?
May I pray immediately after the
Okay,
petition on the reopening of the next.
Wide order dated 5/3/2025, notice was issued in this case. Full stop. The matter is in connection with a prayer for remission of the sentence imposed upon the petitioner by the trial court. Para. On the prayer of Sri H. Sharma, learned additional senior advocate Assam. Matter is adjourned to be listed immediately after the summer vacation to enable him to obtain instructions.
Item 25.
Yes.
This matter also pertains to Panchayat election. Panchayat
Delimitation.
matter.
Delimitation.
Delimit.
Okay, same. লিখিছিলাম নহয় মাত্ৰ। Who is the senior?
Like 20 dollars.
Huh?
26 like.
No, who? S. Dotto.
Keep followed.
Ke kore, ke liখিবা. And we record Mr. Dubey's name, same, huh? Disposed of, huh?
26.
26. VP Bora. Where is Mr. Bora? Okay, no, but you kindly get some of the council. US Bora, PJ Dutta. None appears for the petitioner on call. Baki khine eke hoga covered. If they are available, please ask them to come to the court. But none appears to hear no. They have to be here, otherwise it will not be possible to dispose of on merits. It will not be proper. Kindly get them. Timing guntu eta to aru eta. Tudi aru eta elected. Tudi aru eta. Eta tudi aru eta. "26 it is covered.
May it please your
It
lordship.
is covered.
No, your lordship, this is a little different. Lordship, here the challenge is delimitation or intra-delimitation of a gown, not delimitation at a higher level. So within the gown, usually what
But that is
happens-
also covered by Justice Chaudhary's judgment.
Lordship, I read that judgment. That judgment doesn't deal with the provisions of law of the act that we rely on.
Difficult to accept. Difficult to accept.
Lordship,
It's a very elaborate judgment. It's
yes,
covered
lordship.
everything.
Lordship,
Everything.
that deals with at the above level delimitation of the panchayat, gaon, etc. This is a gaon panchayat. Within a gaon panchayat, how delimitation happens? A gaon panchayat is divided into 10 wards. So what has happened is 80 households of Ward 5 has been taken out from Ward 5, which is
What is the legal right you are suffering?
Lordship,
What is the legal right you are suffering? Which has been
representation of representation. I belong
what
to
rights of your have been infringed?
243, my representative right of a scheduled tribe and a scheduled caste, your lordship. Ward 5 is entirely a majority scheduled caste constituency. From that, 80 households have been removed and taken off to a.
Who are you?
I am 80 households of Ward 5. And I have been taken out and removed and put in Ward 6.
No, is your
which is scheduled
are
tribe.
your voting rights being hampered?
Lordship, the whole, yes, your lordship.
How?
At the end, my representation. I become a minority. Lordship, I may take you through. It requires elaborate listing of the act. I am reduced I was in a scheduled caste constituency. I am now
These are
taken out.
policy decisions, madam. How do you interfere?
No,
Right,
Lordship,
court?
it's in violation of the act.
Let us see which violation.
Yes, your lordship. Lordship, the first thing that our problem is that
So-
after the amendment, it should be under 3A of the District Delimitation Commission.
No, it will number
We do not know who has done it now.
26. 26. Yes,
Lordship,
section.
First ground is, Lordship, the first ground is page 224. This is the report. Page 224. It's the covering letter, the forwarding letter, not the report. It's submission of report on ward delimitation of Tithaugarh district.
224.
224, Your Lordship, of a petition.
Just a minute, please. Yes.
So Lordship, after the amendment in 2023, it's the District Delimitation Commission which shall decide the size of Gaon Panchayat. That's 3A, Anchali Panchayat and Zilla Parishad. Now we have a letter which says, I forward here with a report on ward delimitation as per the prescribed format. And it's signed by the CEO and the DC. There is no mention of District Delimitation Commission. Even the annexure, the signature is at page 227 and it's the CEC and the District Commissioner. They have not filed an affidavit to explain. Has it been looked at by the competent authority or not? And the competent authority is District Delimitation Commission, which consists of the DC, the CEO, and the election officer.
Where is the district delimitation competition,
Section 3A of the Panchayat Act.
3?
3A. The government shall constitute in every district a district delimitation commission to decide the size of the Gaon Panchayat, Anchalik Panchayat, Jila Parishad constituency.
Yes.
The district delimitation commission shall consist of the following, namely DC, chairman, the CEO of Zilla Parishad, member secretary, and election officer. This report doesn't talk about district delimitation commission. It just is signed by 2 of the members of, but there is no mention of election. The question is it actually pursuant to a report by the DDC, or is it just a random act by 2 of the members? So they must file an affidavit. We do not know this. Now, Your Lordship may kindly see what our problem is. May I take
No,
you
this,
through?
224
Yes, Your Lordship.
is a communication.
That's right, Your Lordship. We don't know the report. We don't have the report. They've not filed an affidavit.
No, no, where have you stated that the report is not filed by the commission?
Lordship, we have taken that ground, para 10. We've taken all the grounds in para 10 of our petition.
Para 10, yes. Let us see para 10.
Yes, Your Lordship. Lordship, these are the 4 grounds on which we challenge. Lordship has page 50.
Yes.
That in the present petition, the petitioners have challenged the shifting of household number 1 to 80 of Ali Chinga Gaon.
No, that we have read. Where is the
Yeah, the
Everman?
petitioner has questioned the impugned action on the ground of the same first.
No, we have read, madam. We don't need so much time to read.
Lordship, second.
Where is the statement that that is not done by the commission?
Secondly, it is done by an incompetent authority as the same is purportedly done on 5/11/24, which is after the amendment of the Panchayat Act, which is amended on so-and-so as per 3A. The District Delimitation Commission is the appropriate
Is
authority.
done by an incompetent authority.
Yes,
224 is the 511 letter or what?
yes.
Yes, what do you say, Mr. Kaur?
If they otherwise similar issues were involved in the
Paragraph 11 also, we can
case
finish.
of repetition.
Hmm.
In that judgment, all similar suspect.
No, madam says that this issue is not covered. We found that the issue is broadly covered by that judgment.
The judgment says the competent authority is DDC.
Oh.
We rely on that judgment for that.
Okay, then if another date, if they response to that, otherwise if they have participated in the election and it is not that some community will become.
No, the question which was put by the court that is your voting rights being hampered? That is not hampered.
Not-
No,
But
Lordship.
just a minute. But the response was that the person whom they want to represent, the representative capacity, that is being affected. That is but how much that will hold ground in a writ proceeding?
Your Lordship,
If the substantive right are not in question, why should extraordinary jurisdiction be invoked?
there is no power in, there is no restriction that they cannot participate in the election. They cannot.
Okay, we'll have
participate in
this
the
for
decision-making
consideration
process, Your
after
Lordship.
the vacation. Okay. You just bring instructions on this issue.
Yes.
Others policy decision, we may not be very
Yes.
Lordship, that's,
eager to interfere.
that's a matter of law. So we'll rely on the Panchayat Act and the rules.
Oh. On the heard Ms. G. Goswami, learned counsel for the petitioners. On the prayer of 3K Kaur, learned additionally G. Assam, matter is adjourned to be listed on 28/28, 28 tarikh, 28/7, 28th,
Yes, yes.
Monday,
Obliged.
to enable him to obtain instructions / file affidavit in opposition. Okay.
Obliged.
Sri Sri R.K. Dubey, learned counsel is present for the State Election Commission.
Obliged.
Obliged.
Item 14, thank you.
14.
May I please, raise the Lord?
Yes.
My Lord, this is a
14,
matter
who is for the
for
other
the
side?
Revenue and the deputy commissioner is a party, my Lord.
14, 14. 14, Mr. Das? You file your agenda?
Yes, yes, my Lord, we have filed me. My Lord can fix it immediately after vacation of hearing.
What is the matter about?
Matter about, my Lord, we are claiming that, my Lord, our portion of land as well as the permanent structure has been acquired by the authority for widening of the road, my Lord. Now for that, my Lord, we are entitled for the Right to Fair Compensation Act 2013, my Lord. That has not been provided. Now they have come up with a stand, my Lord, that the area which has been acquired is not an area within our patta land premises, my Lord. That we have by our rejoinder. We have tried to satisfy my Lord, my Lord.
There will be a disputed question of fact. How do you?
Lord can examine the record, my Lord, and the affidavit.
Difficult. We cannot go and demarcate and see what wetlands have been affected.
My Lord. Try to satisfy my Lord if I can, my Lord.
No point of having this pending. At best, you can approach the civil court. These are all factual matters if it is disputed.
No, my Lord, other issues are also there.
No, no. After all, if what is the area concerned?
Area, my Lord, there are different area we have, my Lord, mentioned in paragraph 3, my Lord, at page 5. Amount of land taken for stops, my Lord. Small area, my Lord. In tabular manner, we have stated.
No, if they have said that this acquisition proceeding does not affect your land, where is the scope?
No, my Lord, in fact, our patta land has been acquired, my Lord. That is our specific. and
Yes,
stated.
Mr. Das, where is your affidavit? He is insisting that the patta land has been acquired.
Well.
Okay, we'll have it immediately after the vacation.
Immediately,
Okay.
Mal.
Heard Sri A.R. Bhuya, Learned Counsel for the petitioners. Also heard Sri N. Das, Learned State Counsel, who submits that affidavit in opposition has been filed. Full stop. Para. The matter involves the petitioners have alleged encroachment of their land, of their patta land, for
Widening
of the road. Full stop. In the affidavit in opposition, however, it has been clarified that no patta land of the petitioner
Para 5 and
has been affected. Full stop. The said averment has, however, been refuted by the petitioners in the rejoinder affidavit filed on 2/5/2025. Para. The aspect of involvement of disputed questions of fact will definitely be there in this writ petition. Full stop. Para, be that as it may, on the request made by the learned counsel for the parties, list for admission hearing immediately after the vacation.
Mal.
We take instruction from your client.
Mal. My Lord, in fact, it has already been demolished. Road has
It
also.
is, no, if it's a Madipatta land,
Mal.
we can leave an avenue open for you to seek compensation. That part, we cannot
No, that is-
determine the compensation.
That is correct. That I cannot.
But my lord, our affidavit is very much.
We'll see into that. Okay.
Obliged, my Lord.
Item 13.
Lordship, I was on the judgment of the Lakshmi Narayan Sahu.
Hmm?
The judgment of the Lakshmi Narayan Sahu.
Yes, yes,
Was reading that.
yes, yes. No, you place your case first.
Lord.
195. 195.
If my petition is against the impugned order in original, which your Lordship may find at Annexure 1, dated 20.
Kyle appears for for central central GST. GST. Okay. You, what is your case? You are
Against the order in original for levy of service tax upon the petitioner.
date,
Order dated 2011-2017, Annexure 1,
page.
page 24.
Yes. For levy of
The-
service tax.
Levy of service tax
Okay.
under the Finance Act 1994.
Yes.
We have challenged this assessment order on 3 points of jurisdiction.
Yes.
One was subsequent to introduction of the Goods and Service Tax Act in the year 2017. The power to levy service tax in our humble submission was removed, and they could not have proceeded further in
Yes.
view of the amendment to the Constitution, as well as the omission of the provision of service tax by the Amendment Act. So far, power of saving and repeal by the GST Act under Section 173 and 174, subsection 3 is concerned.
Yes.
That was set at rest by this Honorable High Court in the case of Lakshmi Narayan Sahu.
Yes.
My other point of contention is the power to
What
levy.
does this Lakshmi Narayan Sahu say?
Lakshmi Narayan Sahu said that even although
Repealing.
Chapter 5 of the Finance Act was omitted, it is saved by the repeal section of sections 173 and 174, subsection 3 of the Goods and Service Tax Act.
Yes.
So they have the power to continue.
No, this will go against you.
This point goes against me. This is one part of my contention which I have raised in the debate. Other part is when the power to levy service tax has been specifically provided under the Constitution of India under Article 268, capital A,
Yes.
which totally has been removed from the Constitution itself. Still, the authorities will have power to levy service tax when that power to levy itself has been omitted from the Constitution of India. And there is no saving to that power under the Constitution of India.
268 has been omitted, repealed by which, amended by which constitution?
101st Amendment Act.
Huh?
101st Amendment Act of
One-
Constitution of India. Dated 16/9/2016.
101.
101.
Dated
16/9/2016. 101 Amendment, Constitutional Amendment Act 2016. So the Constitution had provided under section Article 268, capital A, the power to levy service tax upon the Union of
You
India.
want to contend that the basis
The very
of the
basis of the
legislation,
constitutional
of the
power goes off.
basis of the legislation which emanated from 268A that has been repealed or amended. Therefore, in absence of the basis, there could not have been a power to levy tax.
Right.
Okay.
Because after 268A, the power was also enshrined under Schedule 1 of the 7th Schedule to the Constitution, which gives power to the Union of India to levy tax. That category was also removed, as well as the Article 268A was also deleted. So when the whole power of the Constitution itself goes off,
Yes.
whether they will still have power to levy tax.
Yes.
The second point of contention is they have a, even if I presume that they have power to levy service tax. My second point is that I was a works contractor and executing works contract in respect of laying down of national highway roads, which was altogether exempted under the Service Tax Act by the notification issued by the Central Board of Central Excise. and all services related to construction of roads were exempted. I'll come to that notification lot. Once that is there, whether they can still levy service tax upon me, saying that I have supplied manpower supply and not as the works contractor. That is another second point of jurisdictional error by the assessing authority.
Yes.
So the point to be considered by this honorable court is whether under 268 capital A once omitted by the constitution, they still have the power to levy service tax.
Hmm.
For that, may I take a lordship to the Constitution of India, Article 268 capital A. Two 268 capital A speaks of service tax levied by union and collected and appropriated by the union and the states, which has been repealed by the Constitution 101st Amendment Act 2016 by Section 7 of that Amendment Act and brought into effect with effect from 16/9/2016.
Yes.
Then your lordship may come to 7th schedule, entry 92 capital C. Seventh schedule list 1. 92C, lordship may not find it, will find it a footnote, which was also omitted by the Constitution 101st Amendment Act 2016, with effect from 16/9/2016.
Which entry? Entry 92.
Entry 92 capital C.
Capital?
C.
Yes.
So what my whole subject is to once these two power to levy service tax under the Constitution of India itself has been omitted, whether it not be violative of Article 265, which says that tax is not to be imposed by save by authority of law. Article 265 says that no tax shall be levied or collected except by authority of law. And there has been no saving or repeal provision so far Article 268A of the Constitution of India is concerned.
Yes.
Now may I take your lordship to the 101st Constitution Amendment Act, which is at Annex 2, page 48.
Page
48.
Wait. इसका फ्रेंड को ना affordable.
Annexed 2 of the
No, this is. Yes.
Lordship may turn to page 49.
Yes.
Section 7 of the Amendment Act, which speaks that Article 268A capital A of the Constitution as inserted by Section 2 of the Constitution 88 Amendment Act shall be omitted.
Hmm.
Then a lordship had turned to page 52, section 19, which provides a transitional provision.
Page?
Page 52. Section 19. May I read, lordship?
Yes, please.
Notwithstanding anything in this act, any provision of any law relating to tax on goods or services or both in force in any state immediately before the commencement of this act, which is inconsistent with the provisions of the Constitution as amended by this act, shall continue to be in force until amended or repealed by a competent legislature or other competent authority, or until expiry of 1 year from such commencement, whichever is earlier.
Yes.
My humble submission is, lordship, so far it says that this will be saved up till a period of 1 year or until a saving clause or respective amendment act, respective legislation
Saving clause,
comes in.
unless a repealing act is done by the state, respective states.
Got it.
But the limit is 1 year.
1 year. They have come up with the
1 year is the buffer period given to the respective states.
state
That you
for
make
forming
a
states.
suitable amendment of the
Of
legislation.
bringing into the legislation for the
Legislation.
Goods and Service Tax. Goods and Service Tax Act was introduced, and the saving and repealing action sections are section 70 and 74. The lordship has the Goods and Service Tax Act. GST.
Yes. You are referring to the Central Act?
Central Goods Act.
Okay.
Section 173 of the Central Goods and Service Tax Act.
Also 17 Act.
Lord.
Section 1?
73. Amendment of Act 32 of 1994.
Yes.
Lordship, may I read? 173. Amendment of Act 32 of 1994. Save as otherwise provided in this Act, Chapter 5 of the Finance Act 1994 shall be omitted. That is, Chapter 5 of Finance Act speaks of the levy of service tax.
Yes.
Then 174, repeal and saving.
Yes.
I am concerned with subsection 2. The repeal of this Act, of the said Act, and the amendment of the Finance Act 1994, hereinafter referred to as the such amendment or amended act, as the case may be, to the extent mentioned in subsection 1 of section 173 shall not. These are the savings of the powers of the authorities concerned. With revive, not in force or existing at time of such amendment or repeal, affect the provision operating the amendment act, affect any right, privilege, obligations or liability acquired, accrued or incurred under the amended act, affect any duty, tax, surcharge, fine, penalty, and so on and so forth. So my whole submission is, so far this repeal and saving section is concerned, has saved only the power of Chapter 5 of the Finance Act, which levied service tax. But when the constitutional provision of the entire power for levy and collection of service tax under 268A was omitted, which is not saved.
But if you read subsection 2 again,
Lord,
the repeal of this, of the said acts, what are the acts?
subsection 1, Lord.
Yes, and
Save as otherwise
say
provided.
acts and the Amendment of Finance Act.
Amendment of Finance Act.
Finance Act is 1994 is a separate. There is the expression used and. Repeal of the said acts means the acts which finds mentioned in subsection 1. What are the acts?
These are the Central Excise Act 1994.
Hmm.
Save as otherwise provided in this act, and on and from the date of commencement of this act, the Central Excise Act 1994, except goods included in entry 84 of the Union List of the 7th Schedule to the Constitution, the medical
Okay.
and toilet
Yes,
preparations.
no, okay.
So the limited argument is that when the entire power under the Constitution itself is gone, whether they still have power to levy service tax. In view of the omission of Article 268 as well as entry 92C of the 7th Schedule List 1.
Yes.
And the affidavit filed by my respondents, they have not responded on this argument, which is part of my pleading. The second point of contention, Lordship, may turn to Annexure 3 of my petition, Lordship, page 54 onwards. This is regarding jurisdiction on fact. Notification dated 20 June 2012. For various reasons, the central government had power to exempt few activities where service tax cannot be levied. May I read, Lordship? In exercise of power conferred by subsection 1 of section 93 of the Finance Act 1994 and in supersession notification number so and so, dated so and so, published in Gazette of India so and so, the central government being satisfied that it is necessary.
We'll do one thing. We'll have this matter after the vacation. We'll continue the hearing. Today it may not be possible. How much time will you take?
I'll take only 15. I'll learn different. Because everything is this, I'll point out from reading of the internet itself. The judgment.
No,
filed
we thought the matter would not take such long time in view of the pronouncement of Lakshmi Narayan. But he is trying to make out a new case. He has to be given a fair opportunity to place his case.
So let him take what time?
How much more time?
10 minutes so for my submission.
If you can complete by before rising at 1 o'clock, then I'll second
I'll
half.
take hardly 5 to 10 minutes.
Okay, complete it.
I was reading the Annexure 3, page 54, Lordship.
Correct.
The central government being satisfied that it is necessary in public interest so to do hereby exempt the following taxable services from the whole of the service tax leviable thereon under section 66B of the State Act, namely. These are the different nature of services where I am concerned with serial number 13, which your Lordship may find at page 55. Services provided by way of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, renovation, and alteration of a road, bridge, tunnel, or terminal of road transportation for use by general public.
Okay.
Then your Lordship may turn to page 58, serial number 29. This exemption was also extended for services by the following persons in respective capacity. 29 clause H. Subcontractor providing service by way of works contract to another contractor providing works contract service which are exempt. Works contract service in respect of construction of road was exempt. as well as the subcontractor also who are involved are exempt.
You say that you fall within this
Exemption.
exemption.
Yes. Now may I take your lordship to the impugned order and Annexure 1, page 24, operative, the chart from page 25.
25, yes.
25. Muhammad Baharul Islam, address so and so, is a registered service tax SST holding service tax registration number so and so for rendering taxable service under the service category of work contract services, falling under section 65B of the Finance Act 1994 as amended. Based on information that the state noticee had been evading service tax under the service category manpower, recruitment or supply agency services. The assessing authority has tried to levy tax on me by bringing in new nature of service and saying that I'm not registered under that service. Lordship is aware under the works contract, when we execute works contract, the portion, the manner of levy of charge of the bill is concerned is on the labor charges. How much work hour is concerned, how much work of labor is concerned. That is the schedule how we charge bills in respect of work contract is concerned. From that, the present assessing authority has said that I have supplied manpower, which are different category of service on which service tax is leviable.
It is not to do with your construction work. It is a different aspect of supplying
That is
manpower.
the contention of the
That is the
assessing
contention of the department. Yes.
Lordship. He has considered page 26, my schedule item rates.
Yes.
For my work order for that relevant period of time.
Yes.
Description, Lordship may find that labor charges for bed preparation and concreting of DLC work, including Haitian cloth threading and so and so, labor charges for bed preparations, labor charges for cleaning of PCC joints, the labor charges for cleaning before sealant as per instructions of the engineering charge, and so on. They have issued me a so-called notice. I have given a so-called reply, and my contentions has been quoted in page 31 onwards, Lordship. Competing arguments. The state notices submitted their defense reply on 22/5/2017. In the defense reply, the notices submitted the following. All the work order executed by the noticee during the period under the so-called notice was work order related to construction of NH 31 in the section from KH so and so to KH so and so. The main contractor, that is Messrs. Simplex Infrastructures Limited, from whom the noticee was a subcontractor. The work executed by the notice is executed by dry lean concrete and pavement quality concrete laying using
This 24 is the order in original,
Yes.
which has extracted the show cause notice, your reply, and the final order.
And the final order.
What is the date of the order? 21 to 2011, 17.
2011-2017.
Okay. Yes.
I have also quoted the taxable the meaning of taxable service of works contract in my reply, Lordship, which is quoted here. Taxable service under.
What are the findings ultimately?
Ultimate finding was that I was not registered under the service tax category of supply of manpower, and I was.
But was supply of manpower one of the assigned jobs to you under the contract?
No.
You said that you are a work contractor.
I am a work contractor. Part of the work was given to me for construction of the pavements, sidewalls, and all. In that thing, the concreting part was done by me, including my own manpower. So that does not amount to supplying of manpower.
So this manpower supply of laborers pertains to which work? Some other work?
No, the construction of national highway.
No, you said that your assignment was for constructing the
National Highway 31 under the Simplex infrastructure.
where he awarded the main work contract.
Yes, Mr. Coyle, if the job which was assigned to the petitioner was essential and works contract, we are not on the first part, we are on the second part.
Yes.
Which does not, which may have a component of involvement of labor, but he was not on the work of supplying of labor.
Here, my first contention of the retreat is not maintainable because this order is available. This honorable court as well as.
No, after say, so many years,
Yes, Lordship,
will
because
not relegate.
this was kept open.
Huh?
This point was kept open. Lordship in that Lakshman and Sahu, now this honorable court, paragraph 36, 34, 35. In this case, Lordship, notice was issued. That notice was the court undertaken. Here, the final order was passed. Recently, our High Court division bench, in case of DNRC,
No, see, this is a matter of 17.
yes, Lord.
Now, can we relegate the matter to the competent authority?
So they can file appeal if the Lordship condemn the delay. Because Lordship the point which cannot be decided by this honorable court. So this is a disputed question of law.
No, the first part is not disputed. The repeal, that's a point of law.
Which one, Lordship, that is already been decided regarding repeal of section 173. That is the 173. That is already been decided by this one. My land management submitting that provision of 268 has been repealed. So we cannot protect the paragraph 33, 34, and 35. They very clear, Lord. And Lord, please to see the note when the notice was issued. Paragraph page 25. Proposed notice was issued on 28/4/2017 for proclamation of GST Act. Lord.
Yes,
Page 25.
yes.
The proposed notice was issued on 28/4/2017.
Page 25.
Page 25. Top subject. Proposed notice number 24. Darul Islam 28/4/2017.
Yes.
And it was final order was passed on 20th/11/2017. And the petitioner was given opportunity to file his reply also. It's not the case that it was the ex parte order. It was no opportunity was given to him.
No, it's but if he makes out a case of jurisdictional error by submitting to the so-called notice.
Then Lord, may please to see the reasoning. Start from page 39.
39. No, see, but if we have understood correctly, he is trying to make out make the challenge on basically two grounds. One is the ground of the point of law, whether at all you had the power. If he is not successful in convincing the court on the first ground, he will fall back on the second ground, that he could not have been levied something for which he was not assigned any job. His job was a work contractor. His job was not for supply of labor. So the component on which the levy has been done is on the aspect of labor supply, which he is trying to differentiate. Now,
Yes.
if on that point what is your take on that point?
Lord, may please
First
to-
point, more or less, we think Lakshmi Narayan.
Yes, it is people covered.
Second point,
Regarding men,
labor supply or work contract. Then what is your
what's the page, page 40, paragraph 4.2.
page 40?
Lord.
Page
Page 40, paragraph 4.2.
Yes.
I find that the definition of manpower equipment or supply agency as provided its file in section 65-68 of Finance Act 1994 means any person engaged in providing any service directly or indirectly in any manner for equipment of supply, manpower temporarily or otherwise to any other person. Further, in term of 12 section 65-105A of the Finance Act 1994, taxable service means any service provided or to be provided to any person by a manpower equipment or supply agency in relation to equipment of supply of manpower temporarily or otherwise in any manner. Further, I find that with effect from 1/7/2012, with the introduction of negative list of the service service tax regime shifted from selective taxation to comprehensive taxation, and thus manpower equipment supply agency service were then taxable as service in terms of section 66B of Finance Act without reference to specific head of manpower equipment or supply of agency. Then next page, paragraph 4.3. 4.3. I find that the definition of manpower equipment supply or supply agency as contemplated under section 65-105K of the Finance Act does not emphasize a situation where there is a contract for completing the job. From the plain meaning of the above reproduced definition of Finance Act 1994, I am of the opinion that in order to get covered under the said definition, the activity should be providing of service directly or indirectly in any manner for equipment of supply of manpower temporarily or otherwise to a client. There should be either equipment or supply of manpower temporarily or otherwise. I am of the considered opinion that the service tax on manpower supply could be attracted only if the recipient have superintending or control over the labor, which can only suffer from payment terms having HR pay main basis. Only in such case service tax will be attracted and revert charge will be applicable. I find that CPC White Circular dated 15 December 2015 dealing with the applicability of the service tax on service received by the apparel exporters in relation to fabrication of garment registered has been clearly on the subject matter key text from the circular cells to follow. Then circular was quoted. Then paragraph 4.4. On examination of work order, work order dated so submitted by the state notice along with the defense reply, I find that the contract was awarded by Mr. Simplex Infrastructure Limited for purpose of different type of labor supply works at Patsala. On further examination, the state work order dated 15/10/2009, I find that Annexure 3 schedule of labor rates were provided and which are as under. The table is given. Then paragraph 4.5. The above rates are inclusive of all allowance and so. Similarly, Annexure 3 of the work order dated so. Again, then paragraph 4.6. Again, I find that the Annexure 3 of the state work order dated so further posted. Then third table is given. Then paragraph 4.7. Thus, from the above work order, I find that the contract awarded by the service recipient, namely Mr. Simplex Infrastructure Limited, were supply of manpower and not for execution of the work contract, that is construction of roads, dams, canals, etc., which were specifically exempted by para 13.13A of notification dated 26/2012 as amended as contained by the state notice. Therefore, I am of the considered opinion that the state notice during the period from 2011-12 to 2014-15 has provided taxable service under the service category manpower equipment and supply service covered under section 65B44 of the Finance Act 1994 as amended, and had escaped payment of service tax, education station, secondary higher education station in terms of section 68 of the Finance Act, and I hold accordingly. Then paragraph 4.8. I
The
find that
table, Mr. Kyle,
Lordship.
the three tables
Yes.
which have been extracted here,
Yes, sir.
Annexure 3, from Annexure 3, are extracts from the works given to the petitioner by Simplex.
Yes, sir.
This clearly has the aspect of supply of labor.
Yes.
This is not works.
Lordship is aware that in how billing is concerned or RA bill is calculated in a works contract. My bill will be concerned in respect of measurement as well as the labor supply as well as material
But you
supply.
see the purpose, different type of labor supply works at Patsala.
This is extract by the assessing authority.
No, this is not extract. This is under quotes. The award given by the principal contractor, namely Simplex, to you is on the aspect of different type of labor supply works at Patsala. This is cannot be his wordings.
Yes, but when it is documented supplied by the petitioner himself, along with his reply. Page 42, paragraph 4.4, submitted by the said noticee along with their defense report.
The Lordship may compare this schedule
Yes,
with page 26.
26.
20.
Yes.
Here my unit of item rate is, first your Lordship will see, is in CUM. Then serial number 3 is in respect of running man time, RMT. Subsequent page also is running man time. So the entire work as a whole is a work contract where I have bifurcated my bills of measurement based on different units. But as a whole, it's a works contract. It's in a works contract, if I am executing, I will employ my men. I will employ my men and I will supervise them for executing a particular work. That is how a works contract is executed.
Where is the work orders given by purchase preparation?
Work orders, Lordship, numbers are mentioned.
No, let us see the work order given to you by Simplex. Is page 26 the work order?
That is an extract of the work order number so and so.
We want to have a look at the work order.
I presently I don't have Lordship, and on the next page I should.
No, because see, if the work was subletting everything, matter may be slightly different. But from the reading of the contents of the table at page 26, you can have another interpretation that it is the labor which should be supplying, and this is the component of the charges for bad preparation. Because here in the third column, on the description column, it is not on the supply factor of labor, it is the aspect of the works for which labor has been supplied. Mr. Kyle, have you tried to, have you understood what we're?
Yes, sir. I got it.
If in the third column, though the works have also been mentioned, we want to know what was the exact work of the petitioner as subcontractor. Was the entire work for construction handed over to him?
No, subcontract.
No, subcontract. Was the subcontract part confined only for supply of laborers to the works done by the principal contractor, or the works as such was done by you?
Work as such was done by me because it also includes the concreting part of the pavements. Like related to DLC and PQC.
No, this is labor charge.
Yes, it is labor charge.
All labor charge.
No, PQC and these are related to the concreting parts.
No, labor charge and for bad preparation and concreting.
Okay.
These are all labor engaged, 22 numbers. These are all labor charges.
I'll produce the works contract, Lordship, that will clarify the thing. Like that, I think authority can charge under different heads. Now he will say that I have transported the laborers from one place to another. That also includes the transportation service.
No, that can be deciphered. Whether your job ends after supplying of the labor or getting the work executed by yourself, which is within the ambit of the works given to you. But here it does not appear so.
In that case, Lord, content of just produce the work for his concern.
10 lakhs, 11 lakhs.
Because the assessing authority is trying to bifurcate the individual
This
categories of work.
Trade 23, amended trade 26. Amended amount. This cannot be the work amount. See the amount, total amount. 3,41,000. If it's a work, it will be a huge amount.
So I've not been expecting the entire highway, like a particular drain, pavements, these parts were under me. And even otherwise, there's one more point, Lordship. If
But,
I go by the definition of work
Okay,
per track,
when do you want to continue?
the opening day,
Heard Dr. E. Tudi, learned counsel for the petitioner, as well as Sri S.C. Kyle, learned senior standing counsel, CGST. The matter has been deliberated at some length. Para, list for further hearing
can it
on-
be 17, Lord?
on 22nd of July.
20
This is I think a hearing day.
hearing.
22nd of July.
Part third,
We have set further hearing. পিছত মই তাতে দিম। এইখন লৈ যাবা হা?